So I'd like to talk to you, as Surinder has indicated, about, well, three things. And for some reason, my slide won't move on. Ah, there we go. Firstly, the wider benefits of mediation for corporates. Secondly, I'm going to take a step back and look at context of mediation in Kenya and developments that do have a bearing on our economy and business in Kenya in particular. And thirdly, in the limited time available, I'm going to have a closer look at exactly what organizations would need to do to fully embrace mediation. And there's quite a lot to consider there. So the wider benefits, James has already spoken about the many and considerable benefits of mediating disputes compared to adversarial dispute resolution. But there are some less immediately obvious, but nonetheless significant benefits for organizations. First is corporate culture. Now, if you're, as an organization, if you are going to change from being one whose dispute resolution process defaults to litigation, and this is the standard, this is what companies do, or maybe litigation's brother arbitration, still an adversarial dispute resolution system. That change is not straightforward, and that change is going to make itself felt in many, if not all parts of an organization. But as a result, implementing a change across the entire organization is going to implementing a change to become an organization that now seeks dialogue and consensus and mutual agreement in most of what it does. That cannot fail to have quite a marked effect on the company's culture. And does it not stand to reason that if the organization has learned to be less confrontational, the people who work for that organization are likely to do so as well? And given the very well understood costs in terms of productivity, in terms of effectiveness, even in terms of staff turnover, of little battles being fought all the way over an organization, that can only be a good thing. How's my sound now? Are you hearing me? How's my sound now? Can you hear me?
Yes, we can hear you. Proceed. Yeah? Proceed.
Good.
Proceed. We can hear you.
Good. For some reason, my slides do not want to move on. Stuck.
Yeah.
I don't know why.
Yes, I have that also.
You can probably hear me tapping the. Oh, there we are. All right, eventually. So mediation isn't just about the big legal battles that affect companies. I ask organizations to think not just about the full-blown disputes, but also the myriad of other tensions and more minor disagreements that affect the way they do business right across the piece. So whether it's internal staff wrangles or project teams rowing or interdepartmental wars that anybody who's worked in a big organization is very familiar with, or the regular disputes with clients, with customers, and indeed with suppliers, and let's not forget regulatory and tax affairs. When we're thinking about mediation and the benefits of mediation, it really is all those things and potentially more that come into play. And I think we could probably say that, as a rule, wherever you have people involved, well, misunderstandings and the fallouts are not very far behind. So it's no surprise that there is a lot of sometimes low-level disagreement and strife and tensions in organizations, which takes its toll. So whilst it's understandable that organizations may want to just dip their toes in the water and try mediation with one or two cases, I certainly encourage organizations to have a more systemic way of thinking about dispute resolution and the adoption of mediation as a company-wide strategy for resolving all these kinds of disputes. And then when it comes to the big typical commercial legal battles that we initially think about, well, very often they will have started as something small. And if you have a company-wide process of engaging with people, discussing problems at early stage, then that strategy is very likely to pick up and stop these big disputes before they get off the ground, before they become problematic. And then there's perhaps even a wider benefit for companies that really do embrace mediation in business: competitive advantage. So think, for example, and it is just an example of two cases: insurance companies tend to be very big on defending claims. Banks tend to be very big on making claims to recover debts. And in both cases, these are organizations in Kenya with deeply commoditized products, with very little to differentiate between the brands in the market. So a more collaborative, less hostile approach to their disputes, and indeed in their company culture, is at the very least likely to feed into those companies' brands and product differentiation and their marketing messages, and at best could really see companies adding brand value and in turn gaining market share and, of course, the shareholder value that comes with that. And then, you know, mediation can even work before trouble has broken out. So I know of a mediator, an Italian mediator, who helped to manage the interrelations between a whole range of contractors and subcontractors on a big multi-year construction project. I believe it was a dam in Italy. And as we understand, these are the kind of projects which always spawn any amount of litigation, delaying projects, raising costs. Well, as a result of this mediator's involvement, not one single piece of litigation during or after the whole project. So let me move on to developments in mediation internationally. And the big news in the last year is the signing by now 54 countries of the 2019 Singapore Convention on Mediation. Now, I'll explain exactly what that is in a moment, but to do so, we need to go back. In fact, we need to go right the way back to 1958. And some of you may have come across the 1958 New York Convention on Arbitration. Now, what this did was it ensured that arbitral awards could be enforced, would be recognized and could be enforced across borders, wherever, so as long as countries were signatories to the arbitration. And I think as of now, there's 164 signatories to the New York Convention. What the Singapore Convention seeks to do is the same thing, to allow for cross-border enforcement of settlement agreements. This is its full title, the UN Convention on International Settlement Agreements Resulting from Mediation. And a signatory state undertakes to allow a party to move straight to enforcement of a settlement agreement, a mediation settlement agreement, irrespective of where that agreement was made. So your defendant that you need to enforce who's failed to honor a mediation agreement, and by the way, failing to honor mediation agreements doesn't happen very much, but people do still worry about it, doesn't need to worry about proving the validity of that agreement. As long as the basic requirements in the convention have been adhered to, you can go straight to recognition and enforcement through the courts in that country. So like I say, 52 signatory states. Those 52 states represent more than half the population of the world, and you'll see why when I tell you that the USA, China, and India are all signatories. 12 African states so far have signed, includes Rwanda, Uganda, Nigeria. Sadly, as of yet, not Kenya. But like I say, if you're mediating with a party where you would wish to enforce an agreement in Uganda, Kenya doesn't need to be a signatory from your perspective. So it's expected that over time, the majority of trading countries will accede to this convention, and the convention comes into effect on the 12th of September of this year. And you know, mediation is already big business in places such as the USA, in Canada, in Australia, in much of mainland Europe, and in the UK. In the UK, 2018 research reported that 45% of solicitors' contentious caseload were being resolved by mediation. So this really is the future, and mediators all over the place see this Singapore Convention as opening the door to a big upsurge in the use of mediation. So let's have a look at what organizations need to do to fully embrace mediation. Let me start with a question. How many people here have any kind of process in place to triage complaints that come into their organization, and also disputes or early stage disagreements, to try and assess which are the ones that are likely to become troublesome and might benefit from some early senior intervention? All right, so it's a rhetorical question. I'll just leave it there for you to think about. The point I'm trying to illustrate is that most of what organizations do as regards disputes has often not been looked at for decades, and it just follows a well-worn furrow, which, if the matter does not fall away for some fortuitous reason along the way, just results in litigation. The process defaults to litigation. And as we've already discussed today, that's not optimal, even if the case ends up being won. But might it not be nice to at least try to prevent the loss of time, money, commercial focus that James referred to somewhat earlier in the process? So the first thing that organizations have to do is take a detailed look at how things work right now in their organization. Somewhere down the track, disputes are invariably going to involve the legal department, but at their genesis, there's probably nowhere in the organization or its processes that could not feasibly be involved in a dispute. So that necessitates a very broad-based review of processes and the knowledge of the staff who utilize those processes. So the output of this stage of work should be a report, which all areas of the business may then review and comment on. It's very easy, very tempting to skip this stage, this investigative stage in any change process. But given that the objective here is to remodel what is a deeply ingrained and frankly somewhat automated process, doing so is likely to result in a new process which is simply overlaid on what's already there and result in incoherence and complexity, and that is likely to be very fatal to the endeavor. So once that first stage report has been finalized on the basis of feedback received, it's time to consider what is good and what is bad about the existing processes, the opportunities that change offers, and I guess really critically, the threats involved in undertaking change. It would also be wise to spend time working with the board and executive team to identify any particular specific challenges and issues unique to that particular business in designing a new mediation-based process. And enough time needs to be built into the process to allow for an effective feedback loop from directors, from departmental heads, and other key staff, but without allowing the process to devolve into an excess of introspection and, of course, the campaigns from the various parties with an interest in the status quo. So this is the point at which we would design a new process based on defaulting to expertly negotiated resolutions of problems. And as I put here, another way of putting it, dialogue, consensus, and mutual agreement. But let me be clear, if the organization can do that negotiation without assistance, well and good. But if not, or if the negotiation fails, rather than uttering, as James said, the word "see you in court," that's what the process should provide for the bringing in of an appropriate third-party neutral to do the mediation. Conceptually, this is all very relatively easy to design and even to achieve buy-in from stakeholders. It's all a good message, and the stakeholders are likely to be most of the staff of the organization. But more complex, of course, is getting this process to fit with all the other activities and processes of the organization, whilst making those processes simple enough to ensure compliance and consistency in application. In essence, a mediation-based dispute resolution puts together premium negotiation skills with tricky disputes and does it at an early stage. Depending on the nature of the business, that could be as simple as just making sure all disputes go to mediation, and making sure that trading contracts have well-drafted mediation clauses in them is a big part of that. But where an organization's throughput of disputes and litigation is high, these are the cases where the trick is to have an effective early triage process for complaints and disputes. Then issues identified as the most challenging to deal with will then get the best and earliest internal negotiation and or third-party neutral mediation. As far as the implementation of change is concerned, this is of course not to be underestimated. It is an onerous process, and organizations may use their own internal project teams, or they may bring in change consultants. But either way, in such circumstances, indisputable if involved, would certainly expect to be closely involved to ensure fidelity of the underlying principles of mediated dispute resolution and ongoing good understanding of what that means company-wide. Critical. At this point, I'd like just to quickly show you something which Indisputable has developed, a mediation's cost-saving model, which is designed to help organizations understand and visualize what embracing mediation can mean for the organization bottom line. And the best way to explain this is going to be to show you this is a spreadsheet-based interactive model, though in this case for the presentation this is static. Let me just move that out of the way. So this one is the model for defending claims, as it says here. The maths is slightly different for making claims, so there's a separate model. And in the white boxes with the black borders, down here, 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 and here, these are where the user can put in any numbers you want. So in this particular example, we're saying an organization, perhaps an insurance company, has 100 cases to defend a year. And we're going to say the average value of the claims, and I'm working in dollars, is $750,000. Now, we're being generous to this organization. We're saying it's going to win 8 out of 10. It's going to win 80% of its cases. It's going to successfully defend. Legal costs for its lost cases, where it has to pay the other side's costs, $100,000. But the legal costs of its won cases, where typically the court will not award its full costs from the losing party. So the costs overhang of 30,000, with the result that the total legal cost for lost cases is 2 million, but the total legal costs for the cases that you win, more, 2.4 million. Total litigation legal costs of 4.4 million. And of course, the damages that you're paying out on those 20 cases that you lose, 15 million. James mentioned time and if you like, hidden costs in litigation for companies. I'm putting in 10,000 per case to represent that management time spent in preparing for a case and a notional damage to reputation, because of course, by its nature, litigation is a public-facing game. So a total cost of litigating of 20.4 million. We now look at the same 100 cases, the same average case value in mediation. Now we're saying we're strong here in most of our cases. So of course, whilst we might end up settling the cases where we're weak for something close to 750,000, an awful lot of these cases, we're probably going to end up settling for 10 or 20 or $30,000. And it's true, we may end up settling cases that we could have won in court. But remember, we're seeking here to do this process quickly. We're seeking to avoid litigation and to protect our reputation as being a very easy and constructive business to deal with. Mediation costs, we're going to share the mediator's fee with the other party. We're going to have some legal fees for lawyers attending mediation, so $1,000 per case, 100 cases, so $100,000 of total mediation legal costs, and then our total settlement amount of 10 million. Much lower numbers for the hidden costs because the matter is dealt with involving so much less time, $500, and a total cost of mediating the same cases and settling every single case of 10.15 million, which is just under half the cost of litigation, 10.25 million saved. And I can tell you that even if you change this 100 cases a year to 10 cases a year, the numbers drop, but you're still talking about a cost of mediating half the cost of litigating.
So Rupert, how long are you going to be?
Oh, I'm winding up. I'm winding up now, Surinder.
Okay, thank you.
So if anybody wants to know more about that, I'd be very happy to I guess virtually talk people through it and their individual cases on a no commitment basis. In conclusion, then, it's a really exciting time for mediation in Kenya right now. It really is on a growth track. In the last month, the Kenyan government have published a mediation bill, so a mediation act is on the way. And an ever-growing body of mediators from a whole range of backgrounds, legal and otherwise, have been trained, as James can attest to, and they're practicing their mediation very often, very much in the court-annexed mediation scheme that Lady Justice Alawach told us about. And whilst it's true that many lawyers are still very suspicious of mediation and quite erroneously see it as a threat to their revenues, at the top of the dispute resolution, at the top end of dispute resolution practice, the people like Araros and Mohammed Mwigwai and Bowmans and Anjawala and Kana and CMS, all of whom I've spoken to and met to talk about mediation, I found to be having a real growing recognition of the need to have an alternative to adversarial dispute resolution and a desire for deeper knowledge. And I think in many cases, one of the reasons they're still nervous about proposing mediation to their corporate clients is because they just don't think the clients are ready to hear the message. And that's something I'm working with these firms to try and address and educate people. At the very simplest level, I would encourage everyone here to ensure that their new contracts have well-drafted, tiered alternative dispute resolution clauses, which mandate an attempt to mediate before moving on perhaps to arbitration and, if necessary, ultimately to litigation, if it's required. Beyond that, I hope to have the opportunity to help you and your organizations to truly embrace mediation, to help your business save costs, as we've seen, to boost competitive advantage, and in doing so, increase profits and increase shareholder value. Thank you.
Thank you, Rupert.